Good morning, sir. You are Lotharia Jacob.
Yes, ma'am.
And Mr. Jacob, you were previously in court, entered a plea of true to count 2 and a motion to revoke your probation. Looks like you're on probation for the 3rd-degree felony offense of driving while intoxicated, 3rd or more. And let me get that pulled up so that we can go through. Does the state have evidence with regard to any of the other counts?
Yes, Your Honor. Probation officer here can testify to count.
Give me.
Count 1.
Okay. Sure. Nichols, with regard to count 1, you may call your first witness.
Thank you, Your Honor. The state calls Maria Jefferson.
Good morning, Ms. Jefferson. If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Jefferson, are you the probation officer assigned and monitor with Lotharia Jacob?
Yes.
And how long have you been assigned to this case?
Since about September, when he was continued on probation.
Okay. And as part of his conditions, is he ordered to remain in Jefferson County?
Yes.
With an exception for employment, correct?
Yes.
And so during your period of supervision of Mr. Jacob, did the GPS monitor indicate he was in Galveston County, specifically Gilchrist and Galveston, the city of Galveston?
Yes.
Did you ask him about that and try to ascertain if he was there for work purposes?
Yes, I did.
And what did he tell you?
He actually denied going to Galveston and Gilchrist.
When was this conversation?
It was during an office visit on November 28th.
November 20th.
Mm-hmm.
And after that conversation, did he bring you any documentation showing that he was in Galveston County for work purposes?
No, he did not.
Any other witnesses?
No, Your Honor.
Okay. Any witnesses with regard to count 1 then, Mr. Rojas?
Just Mr. Jacob, briefly.
Mr. Jacob, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
All right. Thank you, Mr. Rojas.
Okay, Mr. Jacob, you heard Ms. Jefferson's testimony, right?
Yes.
And you recall the day she was talking about when the GPS showed that you were in Galveston?
Yes.
Okay. So, first off, is it true that you denied to her that you were there?
No, I did not. I told her I was going out there. I worked out of town a lot.
Okay.
And I said I was out there in the morning.
Okay. So, could it maybe just been a miscommunication between the two of you?
That's the only time I was. I used to go to work.
And so, are you telling the court that the days that the GPS showed you in Galveston and Gilchrist, you were actively working?
Yes.
What kind of work do you do?
I do concrete work.
And the concrete work that you take you to various locations
Correct.
around Southeast Texas.
Correct.
And are you telling the court that you did not intend to mislead Ms. Jefferson when she asked you about where you were out of time working?
No, I wasn't intending this.
Okay, you think it might have just been a miscommunication?
Who had been there, she was questioning that you were, don't talk over me, let me finish my question. So if you disagreed with her that you were there for work and not for something else, then why didn't you do anything to give her some information, or your attorney at this point some information?
My attorney did talk to my boss man.
Mm-hmm.
And yes.
With Courtroom, I did speak with Supervisor Mike. I think it is his last name, Judge, but he says that it's true. They do work out of town. They go various locations all over Southeast Texas. He didn't have any documentation as to what date they were working out of town in Gilchrist. He couldn't confirm or deny whether it was this date or not, but he did say they do work sometimes out at the beach or Galveston. He just couldn't tell me whether these dates were those dates they were there or not.
Okay. We're out of the county without permission. And so you had permission to work, but when something comes up, I would think that there was an issue with regard to whether or not you were working on that day, and you didn't provide any verification of that, then it really doesn't leave me much choice at this time other than to find count 1 true. So I am at this time, based on the testimony, going to find count 1 true. Again, there was a plea to count 2 of true. I've received the updated as well, and you pled true to that. So, Mr. Rojas, you may proceed.
Judge, as to that allegation number 2, speaking with Mr. Jacob and again with his supervisor, what Mr. Jacob tells me is that he blew into the breathalyzer. He blew into them late, so that sometimes his job takes him to different locations where he'd have to park in a parking lot or on the street somewhere, and they walk to the job site, which can be, quite a distance away. And by the time he'd walk from the job site back to his car, the time to blow into his machine had passed, and that's why they're coming up to failures. There's no excuse for being late, Judge. He should have known when he should have been there, made plans. But it's not like he was blatantly not blowing into the machine. According to him, he was doing it. He was just doing it late, and it's because he was at work and the job sites were quite a while away from where the machine was parked in his car. What Mr. Jacob is asking the court to do this morning, Judge, and I know it's hard to ask this from the court. He's asking the court to reinstate him. He's already been to the JCDI more than once, I believe. I don't think you've got any positive or positive tests for alcohol. It's just the timing on getting it done. I've spoken with him on several occasions about how important it is for him to take these tests whenever the court tells him. It's not up to him. The court tells him when to do it, and that's when he's got to do it. I think he understands it now.
But Mr. Jacob, you can't just keep messing up and then say, okay, I get it this time. Just let me out. I'm going to do it. You were here. Okay.
Judge, and I don't think Mr. Ross intentionally misstated, but because it's not on the report, but in the admin hearing, there is a positive alcohol test mentioned from early November. I know he may not have that in front of him. Just want to clear that up. But that it was a low blood alcohol at 8:00 in the morning, November 2nd, 2024.
Yeah. I see that. It's 0.003.
At 8 in the morning.
At 8 in the morning. So. And then missed subsequent test that day. I mean, okay. I want to make sure that I have this right. So it looks like you went to the Unity house for 30 days. Within 2 months of the release from there, and this was at the beginning of your probation, let me go through. Began JCDI program April of 2022, shortly after you got on probation. And since, therefore, you were ordered to complete both tracks of ISF, which it looks like you did, completed December 28th of 2023. Then you go back to JCDI for aftercare, again struggled to comply, testing positive, forging your required meetings, and operating a motor vehicle without an interlock. This led to unsuccessful discharge from JCDI and a motion to revoke. And so you came here on a hearing on a motion to revoke. I left you on probation, continued you, ordered you to re-enter the JCDI program. You were going to be on the high medium caseload, continue with your portable monitoring device, and it was going to be zero tolerance. Then we're here again with failing to comply with that portable device. At least it looks like 19 times. You didn't do that. And then we've got the issue with you being in Galveston and Gilchrist without permission. So it looks to me like you've tried and started, but never finished JCDI. Is it 3 times? I believe. But I'm supposed to just go, and you've been to ISF and you've been to the Unity House. I mean, when I'm saying that out loud, think about how it sounds for you to go, well, just let me out this time. I got it. I got it. I'm going to do good this time. You see what I have to worry about? I have to worry about everybody being safe. Mr. Nichols?
I'd urged a 5-year cap in September, Your Honor. There was no agreement on sentencing in this case for today. But I just feel that zero tolerance needs to be zero tolerance, because after that, it only took a couple of weeks for him to start violating.
So, Mr. Jacob, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. I've already found count 2 true based on, no, the opposite. You pled true to count 2. I found count 1 true today. I'm going to find sufficient evidence to revoke your probation, and at this time, revoke your probation. I'm going to reassess your punishment at 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I need you to sign this, and I'll give you a copy. It shows this was not an agreement, so you do have some rights to appeal. You can talk to Mr. Rojas about that. Good luck, sir. Thank you, Neil. Mr. Rojas, you may proceed with argument.
Thank you, Judge. In the updated PSI, the recommendation, the last recommendation from probation is safety continuum.
Go ahead, I'm sorry.
And certainly, Ms. Harris is willing to do that. However, she would ask the court to consider something else given her circumstances. She's, as stated in the PSI, she's heard things about the JCDI program. She would like to have a chance in the JCDI program. Certainly, she feels that the reason that she relapsed was because we had some things going on in her life. She had a couple of cousins back last year that got shot, and her dealing with that herself and seeing the way it affected her mother caused her to relapse. But the reason she's asking for JCDI rather than safety, Judge, she's got a young child, a young daughter who has some medical issues. Her mom has been taking care. Ms. Harris's mother has been taking care of the child while she's been in custody, and the mother is here. The grandmother's here this morning, and I've spoken with her, Judge. When Chastity is out and she's taking care of the child, the grandmother says that she takes care of the child, and she's tremendous help to the grandmother taking care of the child. And the child is going to need some surgery coming up, and the grandmother is being overwhelmed right now with that surgery and the medical issues. And for the child and the grandmother, more than for Chastity, Judge, we're asking for you to consider continuing her probation and considering JCDI rather than safety.
I feel for your family that is helping take care of your child, but it's not on me if you're not there to do that. And so using that doesn't really go very well with me, because it's you that put yourself where you are. You've already been, you're a convicted felon. You've been given chances at probation that got revoked. You got time in prison. Then you are placed on probation and given this great opportunity for possessing a firearm while you're on probation. You get another case while you're on probation for the first unlawful possession. I give you another chance on probation with a possession of a controlled substance. I get the argument that you need help. I send you to SafeP. You do SafeP. You get out for ongoing support. You go through the drop program. Did well for a little bit, relapsed, and when you relapse, they're trying to get you more help, but there's just not. You've been on the high medium risk supervised caseload. You've been to SafeP. You have successfully completed the moral recognition therapy. You've been through the transitional treatment caseload, and you've been to the Spinal Tap outpatient center. There's nothing else. You are making choices now that addiction, at some point, you have to take advantage of the substantial tools that you've been given. We're going to find, Ms. Harris, that again, you entered your pleas of true to counts 1 and 3 freely and voluntarily. I find those counts true. Also find count 2 true. Find sufficient evidence to find you guilty in each of your cases. And cause number 17-28222 finds you guilty of the 3rd-degree felony offense of possession of a firearm by a felon. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 20-35466. What level offense is that one? It could get worse. You probably shouldn't talk. It could get worse. I had written down a higher number. So your attorney bought you, or your grandmother. It's a second. And cause number 20-35466 finds you guilty of possession of a controlled substance, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. They will run concurrently, which means together at the same time. I'm going to hand you, I need y'all to sign this, please. These were not plea agreements. You do have some rights to appeal. You need to sign that with your attorney showing that you have a right to appeal. And then I'll get you a copy of that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this by now, but I'm required to read this to you. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas and hear it. Good luck to him. You can go back with the bailiff. So, Mr. Turner, you were just revoked back in October of 2021 and received a state jail sentence. Whose court was that in? Was that here?
Yes, ma'am.
So I know then for certain that I read to you those written admonishments about not possessing a firearm, right?
Yes, ma'am.
And you have a prior terroristic threat, you have a prior assault causing bodily injury, and you're walking around with some other young person with guns and shooting at random. Last month and a half, 6 incident reports from the jail where you cannot follow the instructions. At this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an plea agreement that I followed, and so you waived your right to appeal. I understand that you're fairly young, but you've been given some opportunities already, and obviously you're out there doing some things that could lead you to be in here for something much worse, where you've actually shot someone. It's just not, the running around with guns and shooting has got to stop, and all I can think of is the longer I can keep you away from society, probably the better at this point, because you can't learn. You haven't been able to learn from your past mistakes. I hope that you do, and I hope that you do this time and you get out and you change your life. But you're going to have to make those changes. There's help for you out there wherever you need it. There's help in TDC if you need it. But I don't feel like I have a choice today. I'm also handing you, just like I did before a couple of years ago, the written admonishment regarding your ineligibility to possess a firearm or ammunition. I'm required to read this to you again. You should pay attention. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Do you understand?
Yes, ma'am.
All right, you can go back with the bailiff. I feel like I've seen this. You have maybe one of the co-defendants that I
No,
did something
nothing
on. This is
aware of, Your
very
Honor.
familiar to me.
Unfortunately, it's a pretty common fact pattern. It's 4 people riding around the car at 12:30 in the morning. There's 3 guns in the car.
Yeah. Okay.
And I'll just so the court's aware, the driver, Mr. Joseph Matthews,
Mhm.
who was charged with felon possession of a firearm from the firearm that's in the glove box of the car.
Mhm.
He was on parole after taking a plea deal for the offensive tampering with evidence for his involvement in a homicide. Mr. Dorsey, who filed with the police once they discovered a firearm in his waistband, is also a multiple-time felon. And then Mr. Sam has been convicted out of Harris County and is a felon, as well as being on probation out of this court, Your Honor. So there was 3 guns in the car with these 4 people driving around.
In a deferred probation motion to revoke a deferred probation, they're typically, you're entitled to a bond, but there is a provision that allows me not to. I think it's just based on the evidence, which is what I'll do. And if there's any other issues, we'll do it that way.
Judge, can I say so?
Probably shouldn't. Mr. Sam, I'm going to deny your attorney's motion to set a bond in cause number 22-41263, based on the nature of the underlying offense that you're on probation for, which is a robbery, where you were allowed to plead to the lesser included in that case for a probation, and the fact that you have numerous violations, and one of those being a felon in possession of a firearm. Because you also have, it looks like there's a felony conviction that you have out of Harris County. So the fact that you had that conviction and got the probation already was, anyway, okay. And so based on the nature of the underlying facts that are alleged in that new offense, the fact that it is alleged that you were in a vehicle with several other people with at least 3 guns, other ones that are on parole and convicted felons as well. Obviously, all of that's a violation of your probation, I think, in the interest of the safety of our community. And based on all of the factors set forth in 17.15, I am going to deny that bail be set in this case. If you will get that other case fast tracked if possible, so that it can get go through the grand jury process. If something happens and that case is not indicted, then I will reconsider at that point. Mr. Rojas, I would allow you to file another motion and I would reconsider that. And then once that case goes through that process, if it is indicted, then I want to move as quickly as we can. If there's going to be a plea of not guilty in that case, and then it would probably be my desire to go forward on that motion first if we need to.